Hi, Attorney Josh LeRoy. Today we're talking about breath test machines. In Florida, they're the Intoxilyzer 8000. The Intoxilyzer 8000 was first approved by the state in 2006 and has become the standard and only approved breath test machine across the state. The Intoxilyzer 8000 measures a blood alcohol content of the person that blows into it. And according to the Florida Department of Law Enforcement, it measures the deep lung air. Deep lung air is defined as the breath sample. The instrument is designed to analyze deep lung air, the type of breath sample which renders the most accurate breath alcohol level, representing the alcohol concentration circulating in a test subject's body. Deep lung air is obtained from the deepest part of the lungs and is best obtained by having a test subject normally inhale and provide a continuous sustained breath sample for as long as possible. A valid sample is obtained if the machine records 1.1 liter of breath. That is a breath sample of a continuous flow of about 1 second. It is not necessary to provide a multiple second breath sample. The Intoxilyzer 8000, besides recording the BAC, or the blood alcohol content, or the breath samples, will also provide the amount of liters of breath that a person has provided. And those can be obtained, so those can be analyzed to determine whether or not a person provided a sufficiently large breath sample, should there be an error with the machine. Or should the person say that I tried to blow and I continued to blow, the machine wasn't working properly. The Intoxilyzer 8000 results are admissible in the state of Florida in criminal courtrooms. There are limited exceptions where they can be kept out. The most common question involving the breath test machine is, should I have provided a sample, or should I provide a sample? If you have not been charged with DUI at this point, if you have not been arrested and you're watching this video for educational purposes, then I recommend not providing a breath sample should law enforcement ever request one. Providing a breath sample to a law enforcement officer is cooperating and providing evidence that's going to be used against you. The reality is that if you provide the breath sample, at that point you've already been arrested, you've already been transported to the testing facility, usually in handcuffs, usually in the back seat of a car. And if you provide that sample and you're under a 0.08, you're not getting unarrested. You're not being released at that point. They're still going to keep you in jail, and they're still going to charge you. The reality is they may even ask you for a urine sample thereafter. Alternatively, if you provide the breath sample and you blow over a 0.08, you've just provided additional evidence for the state to use against you in the criminal proceedings, in the criminal trial. So if you have the opportunity to refuse a breath test and you have not been arrested, I recommend you do so. If you're watching this video and you have already been charged with a DUI, do not stress over the fact that you provided a breath sample. Do not beat yourself up over it. We cannot change what has already taken place, and we can address that in the near future. What are the results of refusing a breath test? The reality is that your driver's license will be suspended. There's a mandatory 12-month suspension for a first refusal and an 18-month driver's license suspension for a second or subsequent refusal. However, you do have the right to challenge the suspension of that 12-month or 18-month. There's a formal administrative review process with the Department of Motor Vehicles, and I encourage you to look into that and to contact me to discuss those issues. If you've been arrested for a DUI, or if you are having questions about the breath machine, please contact me, Attorney Josh LeRoy. Look forward to talking to you. Thank you.